So in this segment, we're going to be talking about the High Court to look into Prime Minister's Patel bullying decision. So the High Court has decided to look into Boris Johnson's decision that Home Secretary Priti Patel did not break Whitehall rules over bullying. So there are differences between the ministerial code and employment law, which is something they talk about within this article. This is a pretty well done piece, I think. It's done well. They do explain it fairly well. So we're going to start reading into this. And Priti Patel is not out of the hot water over the looks of things, because if it's the case that the High Courts do declare that Priti Patel did bully senior civil servants, civil servants and other staff in general, then it's going to put Boris Johnson in a very awkward position, because Boris Johnson went so hard to bat for Priti Patel that the person who did the inquiry into Patel's bullying quit. He resigned because he realised that his job is ineffective, and that he told the Prime Minister unequivocally that Priti Patel is in the wrong here, and the Prime Minister said, nah, she's not though, is she? She's not. So the Prime Minister kept Miss Patel in post last year after he found she had not breached the ministerial code, which sets behavioural standards. But the FDA, Senior Civil Servants Union, which brought the case, argued that Mr. Johnson had erred, so they're claiming Johnson is wrong. The court will now give a full hearing into its claims against him. This will be hilarious. The government opposed taking the case forward in this way, saying the ministerial code was separate from the law and should remain so. In November, an inquiry carried out by the Prime Minister's head of standards, Sir Alex Allen, found that Ms Patel had unintentionally broken the ministerial code. So Alex Allen said Priti Patel did break the code. Boris Johnson said, nah, but she didn't though, did she? And that's where the standoff happened. Her approach to staff on occasions amounted to behaviour that can be described as bullying in terms of the impact felt by individuals, it added. But it said the Home Secretary, who offered a fulsome apology, had sometimes legitimately not always felt supported by others within the Home Office, probably because you're doing policies that maybe they didn't really believe in. Maybe. So we got some analysis from Dominique. This decision is a really big deal. Ministers are appointed in the name of the monarch and can be sacked on the Prime Minister's whim. Civil servants who work under them, however, are hired under normal employment law with all the protections against bad treatment that come with it. So you can't bully these people or treat them like rubbish, because they are protected by employment law. The FDA's argument is that the elements of the code on bullying and a judgment on whether someone has been victimised must be open to scrutiny under employment law, and the fact that if that is the case, then Priti Patel will be in trouble, because they will mention the fact that it was found by Sir Alex Allen that Priti Patel had unintentionally broken the ministerial code and bullied people. That's I think that would be enough evidence to kind of put the nail in the coffin here. It's very, very stupid what Priti Patel and Boris Johnson have done. They never expected this to happen. But simply put, if it's the case that the court finds in favour of the this union and the civil servants, what happens then? It's going to be very open that Boris Johnson ignored bullying allegations from civil servants, and this will blow up again that another government cover-up to protect one of their stooges. That's what's going to happen. So we'll keep a close eye on this one. It says here, if the FDA wins the case, it would be an absolute first. Some of the Prime Minister's conduct may be open to further scrutiny under employment law, as if he were any other kind of boss, and that would probably be a massive constitutional question for the Supreme Court. Could be asked to redefine the boundary between politics and the law. But the simple case is, if you're bullying members of staff, yes, you are held within the ministerial code of conduct. But at the same time, you cannot treat staff badly, especially staff that are under contract and have protections under employment law, and also part of unions. Do you not think the unions will not fight on behalf of their members? Are you that stupid? Just ridiculous. This entire situation is, she should have been sacked, but Boris Johnson stuck by her. Very stupid. Anyways, look, we'll keep an eye on this case, and I'll let you know what happens if the Supreme Court finds in favour of the claimants, the union and the civil servants, or does it find in favour of the Prime Minister? I'll keep you up to date with that. And, if they do find in favour of the unions, will this kind of push Boris Johnson to go for a more Americanised political style court where the Parliament would decide on judges? Would that push Boris Johnson in that direction? Because that's something the Conservative Party have spoken about in the past. But anyways, look, I'm going to leave it there. Let me know what you think in the comments below. Like, comment, share, subscribe, and hopefully I'll see you in the next one.